Hey class, welcome to week 8. This week we're going to talk about open records, open meetings, so basically public access to our government, as well as issues of outsourcing government operations to private entities, so government contracting. And these are both areas where it's important to keep accountability in mind. How does the public gain information about our government? How do we hold our government contractors accountable? Before we get started, now that you are halfway through the semester, please start working on, or at least thinking about, your policy analysis memo. Your perspective is going to be due next week. It is ungraded, but it's just a way for me to make sure that you're on the right track. So for your policy analysis memo, this is due at the end of the semester, I want you to pretend that you are working for maybe a government executive branch agency or a nonprofit, and your boss has asked you for a memo outlining policy options regarding a specific issue and recommending one of those options to move forward. So in the policy analysis memo, you should not be writing about whether Congress should pass or repeal a law or how a court should rule on a case. Your memo does need to discuss laws and potentially court opinions, but in relation to executive branch agency action. So in your policy analysis memo, you're going to need to explain why the issue is important. You want to provide some background information to orient the reader, such as relevant statutes, regulations, and case law. You're going to need to identify and analyze the pros and cons of at least 2 policy options. Now remember, sticking with the status quo may be a valid policy option, so it's fine if you want to discuss that. You do have to make a recommendation to the decision maker, much like you made a recommendation to the Pollinator Protection Institute in the memo that was due the other week. In your recommendation, you should discuss why you believe the decision maker should choose the option that you are putting forth as the best option. And you should talk a little bit about how to implement the option. So you don't need to go through the entire implementation process, but you should explain the best way to begin. And finally, you're going to need to highlight any challenges that the agency might face. So whenever you're considering creating, repealing, or changing a policy, consider the roadblocks that you might encounter, and that might include the potential for lawsuits. Now, in your policy analysis memo, you do not need to use every type of legal resource. If there's no case law that makes sense to use in your memo, then don't worry about that. But you are required to use at least one type of legal resource, so you might just be looking at statutes, for instance. And by one type of legal resource, I mean statutes, not a single section of a single statute. I do recommend that you use a minimum of 2 or 3 resources, because whenever we're talking about agency action, keep in mind that is codified in the CFR, so you want to look at regulations. But you can also use legal encyclopedias, law journal articles, statutes, regs, case law, agency white papers. There's a wealth of information that you can use for your policy analysis memo. Now, speaking of memos, let's go over your first graded memo about the potential for adding the small-flowered rock crowfoot plant to the list of endangered species. So for Memo 1, you were asked to advise the Pollinator Protection Institute, PPI, on whether the plant could be added to the federal list of endangered species, and assuming yes, the process for doing so. The assignment instructions also told you that you had to provide a rationale for your decision, a description for the process of protecting the plant, including any specific requirements, the anticipated timeline, and potential hurdles. So a good memo would include several items. The first is enough background information to orient the reader. Second, an actual recommendation. You must have recommended at least one course of action to PPI, and you must have supported that recommendation with citations to the Endangered Species Act and or its regulations. Third, whether or not listing the small-flowered rock crowfoot is possible, the memo did have to address the listing process, including specific requirements for any petition and the estimated timeline, again with citations. Fourth, the memo should have included a discussion of at least one, but definitely could be more, potential hurdles and how to overcome them. So in grading these memos, I also looked at how well you integrated resources from our class, such as the Endangered Species Act itself and its regulations, and possibly other resources such as the PETPO case. And as with all graded items, proper citations, grammar, spelling, all of that's important. Okay, let's take a look at these requirements in more depth. So first, you needed to provide sufficient background to orient the reader. The reader should understand the benefits of the plant, potential medical benefits such as treating pain and fever, potential agricultural and environmental benefits such as offsetting bee colony collapse. You may have wanted to note that Native Americans use the plant for medical reasons, as that might bolster, the support for the plant's medical benefits. Also, the reader would need to have a little bit of a description of Vessla, a clean energy company, and what its plans were and why those were endangering the plant. Second, it wasn't enough to simply describe PPI's potential options. So you actually had to recommend that PPI embark on a certain course of action. You weren't limited to a single recommendation. And in fact, many of you recommended that PPI begin the listing process while also negotiating a candidate conservation agreement with Vessla. So good recommendations. Third, regardless of whether you recommended listing the plant, you did have to discuss the Endangered Species Act listing process, including the specific requirements for petitions. So the best memos put all this information into sentence format and called out the important requirements while also noting that there were more mundane requirements, like the petitioner's signature. Fourth, you had to discuss the anticipated timeline for the listing process. I realize this created some confusion, but that is why we had the D3 discussion board available. It was there for you to ask questions and collaborate with your classmates. So your memo should have informed PPI that the listing process, could take nearly 2 years based on the time period set forth in the ESA and its regulations. I did want to see at least a partial breakdown of this 2-year period along with citations. You could see that I've got that here on the slide. We've got the 30-day waiting period after filing, 90-day initial review, 12-month status review, 60 days for public comment, not the typical 30, and then the rule wouldn't take effect for 30 to 90 days after it was published in the Federal Register. So those are some of the items that I wanted you to be able to hit. Your memo also had to identify any hurdles PPI might face. And whenever you're going to discuss hurdles or obstacles, you should also talk about ways to overcome them. So in this case, hurdles might have included lack of evidence to support listing the plant, not enough time to work through the listing process, potential inability for Fish and Wildlife to regulate a plant on private, non-federal land, could have been backlash from the community, which stands to lose jobs, lawsuit by Vessla, public relation nightmare for PPI, so you should have noted at least one of these hurdles. Now, the biggest hurdle in terms of the legal requirements was that lack of supporting evidence to list the plant. And so you could note that the agency has the option of protecting the plant under an emergency rule. Now, while PPI cannot force Fish and Wildlife to use the emergency process, you at least want to make PPI aware that an emergency listing process exists, and it would buy it 240 days to collect more data on the plant. Additionally, PPI could oppose the Small Business Administration's funding of the project because federal agency actions cannot jeopardize an endangered or threatened species. Now, this, of course, would require that the crowfoot be an endangered or threatened species, but PPI likely wants to ready itself to do as much as it can on multiple fronts to protect the plant. Also, as we talked about on the D3 board, PPI could approach Vessla about entering into a candidate conservation agreement. That would protect the plant, even if it's not designated as threatened or endangered. And finally, you needed to integrate some of the legal materials that we have covered in class. So because agency action is governed by both statutes and regulations, And because PPI is requesting that an agency, Fish and Wildlife Service, take a certain action, your memo should have referred both to the ESA and its regulations. And then some of you also integrated case law like PETPO. That was great. So just in general, some tips for your memos, because you're going to have to write another one in class and then your policy analysis memo at the end of the semester. If there is a discussion board for collaboration, you should use it. Talk to your classmates about the assignment and kick around potential answers or ask me questions. Our D3 discussion board had over 80 posts about what people plan to include in their memos, and a lot of those posts provided specific U.S. Code and CFR citations. On that discussion board, we also covered candidate conservation agreements, and I gave you some legal citations for those. Additionally, think back and remember the basics of legal research, and that includes skimming the table of contents for statutes and regs. In this case, the regulations for adding a species to the endangered species list, they specifically included this section titled Emergency Rules. So that, if you skimmed the table of contents, you would have realized that there might be a way to get the plant listed more quickly because there's an emergency rule. You also want to cite specific paragraph and subparagraph numbers. This is the equivalent of citing to a page number in a scholarly source. So if you were writing a non-legal memo or paper, you wouldn't just cite to an article, you would actually cite to the page within the article where the reader can find the information that you're discussing. And that's what you want to do for legal memos as well. So cite to those paragraph and subparagraph numbers. And this can actually be helpful to you later if you have to refer back to the memo. Because citing specific paragraphs, that means that you're not going to have to retrace your steps. You're not going to have to do all that legal research over again. So in my job, I actually rely on my prior memos quite often. It's nice to have those citations at my fingertips. And this could even be useful for you in this particular class, because if, for instance, your policy analysis memo focuses on threatened or endangered species, you might want to refer back to M1. So those are just some tips on memos, and now we're going to jump into what we're going to learn this week. Okay, so today we're going to have sort of two different lectures. One's on public access to government, and then one on privatization of government services. This lecture is a lot more generally applicable. I'm not focusing specifically on environmental law or all hazards management law. But the key, I will focus on those a bit, but public access is really key to both of those fields. A clean environment depends on our ability to understand the environment as a whole, understand localized ecosystems, and also the human impact on nature. And many environmental law cases are basically won or lost on the ability to get certain information from the government in a timely manner. And we see that, in a civil action where the attorney needs a report, and it would have been really helpful to get that report, years before he finally did. Emergency management also has to be transparent in order to be fully effective and to gain public trust. And agencies in both of these fields, environmental and emergency response, have to contend with open records laws, open meeting laws, and also with government contractors. So that's why we're going to talk about this today. So we've talked about the need to hold agencies accountable to the public. And one of the ways we do that is through public access, accessibility. Keep in mind that accessibility requirements, they really affect a lot of what public administrators do. So as a public administrator, you need to be aware that members of the public can get access to your emails, final memoranda, and other records that you generate in the course of your work. And in my job, we call this the Washington Post test, because the University of Maryland College Park is just a few miles away from DC, and the Post is our local paper. And so we don't want to do anything that would look bad splashed across the front page of the Washington Post. We also want to be accountable to the public, and we don't want to be sneaky and try to hide information. So transparency really is the best option for the majority of government work, with some obvious exceptions like national security and personally identifiable information. Public access includes the right of the public to comment on rules that agencies are formulating. We talked about that during our rulemaking lecture. The right to access government records, and the right to attend certain government meetings. And there are three main statutes that apply government-wide, federal government-wide. And one of these is the Freedom of Information Act, or FOIA. That lets us obtain written records from the government. There is the Privacy Act, which actually prohibits the government from disclosing certain records to us that relate to private individuals. And then the Sunshine Act, often called an Open Meeting Act at the state level, it allows the public to attend government meetings. That's why you can attend, your local city or town council meetings, as well as General Assembly, and even go to Congress. So public access is new. It's a new concept in our modern world. But back in Roman times, the government actually required the publication of a daily public record, and it was called the Acta Diurna, or Daily Acts. And it included government notices, legal proceedings, outcomes of trials. It operated really a lot like today's Federal Register. And the Roman government issued this daily record starting around 131 BCE. So in Roman times, there was actually a surprising amount of public access, at least during the Roman Republic. Now, when Julius Caesar was elected as consul, he actually mandated open government. He changed the Acta Diurna over to the Acta Senatus, and basically made the Roman Senate's actions transparent to the government. Now, Caesar was beloved by the public, but his intent actually wasn't to allow for more transparency for the public benefit. What he really wanted to do was undermine the Roman Senate by horrifying the public with all of these sausage-making details of the legislative process. So after the fall of Rome, thoughts about public access changed. In the U.S., we really didn't have public access until the mid-1960s. So prior to that, at common law, it's the state that is supreme, the state is a sovereign, and the public doesn't really have any ability to question the state. But once, when the United States was formed, we wanted the public to have a lot more control over the government, because we are a government by the people and for the people. And in the mid-1960s, we really started shifting towards transparency in federal government. So there was a lot of public access back when our country began because of freedom of the press and the expansion of printing presses, which actually operated quite a lot like social media. People could write their opinions, have them printed out as pamphlets, and those got widely circulated. Then we kind of scaled back from public access because we entered the era of broadcast media. And although we tend to think of this as, broadcast media, there's a lot more information. It was actually quite a number of, limited groups that controlled the flow of information. If you think about it, back in the day, you had like the big 3 TV channels. We didn't have cable. And so the public was more of a passive consumer of information. In addition, the size of the government grew so much that it became pretty difficult to remain transparent and open. But after the McCarthy era, all the accusations that people were communists, the American public started to realize that the government was playing an increasingly significant role in the lives of citizens. And a lot of this, as we discussed, had to do with regulations that were issued after the Great Depression, and then because of the emerging technology and globalization of the world economy after World War II. So the government really was getting more involved in the lives of people. And throughout the 60s and 70s, there were all these revelations of government wrongdoing. And most of these were actually made public by the mainstream media, like newspapers, and that prompted calls for access to and accountability in the federal government. The government wrongdoings that angered the public were related to McCarthyism, related, blacklisting of innocent Americans, related to Watergate, and also related to the Vietnam War. And also proponents of transparency in government were pretty strenuously arguing that we as American citizens had a right to be involved and a right to review and understand the government actions that concerned us. So as a result of this public outcry, And actually, there's a lot of pressure from mainstream media, primarily the Washington Post and the New York Times. Congress and state legislatures began enacting laws to give citizens the right to see government records, attend government meetings, and comment on proposed regulations before they became final. So the Freedom of Information Act, FOIA, is probably the best known of our public access laws. It became a law in 1966, so it recently had its 50th anniversary. It is part of the Administrative Procedure Act, and its purpose is to ensure an informed citizenry and advance democracy by acting as a check against government corruption and a way for us to hold government officials accountable through this idea of transparency. So FOIA has a pretty broad reach, but keep in mind, it is about records. It requires the production of agency records. Mostly this is records that are in the possession of an agency. So if an agency doesn't keep a certain type of record, the agency is not required to create that record. It can just tell the person making the FOIA request, sorry, we don't keep that type of record. Now, records can include written documents, emails, information held in databases, really a wide variety of things that are written down somewhere. So this helps with transparency because, if you as a government employee are aware that this memo that you're writing or this email that you're going to send, that might become accessible to people, you're probably going to be better about acting responsibly and in line with the law. So FOIA creates this openness and this presumption of disclosure. FOIA assumes that the government is going to disclose records to the public, even if they've got to redact portions of it. And FOIA creates this type of openness through 3 different requirements. It has a publication requirement, an inspection and copying requirement, and the big one for FOIA is production upon request. State governments also have open records laws, and they substantially mirror FOIA, and in fact, a lot of state governments rely on federal court interpretations of FOIA for their own state open records laws. Okay, so the first of these FOIA requirements is the publication requirement. So this actually should be pretty familiar because we've discussed it unknowingly throughout the semester when we talk about information that agencies have to publish in the Federal Register. So for instance, the fact that agencies have to publish their drafts of regulations, that's actually part of FOIA's publication requirement. It's also found elsewhere in the Administrative Procedure Act, but FOIA is really what bolsters the public notice requirement. Agencies also have to publish on a regular basis a description of their central and field offices, basically where they're located and how you can access them, a statement of how the public can obtain information, and that's got to include a phone number and an email address for an agency FOIA office. Agencies also have to publish statements about how they carry out their functions, including their formal and informal procedures, how agencies can get documents related to those procedures, and then their interpretations of their regulations. And then, of course, anything that gets added, removed, or changed in previously published information also has to be published again in the Federal Register. So that's the FOIA publication requirement. There is also an inspection and copying requirement. And this requires that agencies make certain information available to the public. Inspection is just the right to view the information. Copying, as you've probably guessed, is the right to make a copy of that information. So all orders and final opinions from adjudications, any unpublished policies and interpretations that the agency relies on for conducting its business, administrative staff manuals, instructions that affect the public somehow, those have to be made available to the public. This all began as what we call the reading room requirement. So agencies had to provide a location for people to actually come in physically, review, and make copies of agency documents. So these were originally all physical locations. They still exist as physical locations. Agencies in Washington, D.C. in particular have actual rooms where you can just sit and read through agency documents. Now, pretty much every agency also has an online reading room, their electronic reading room, so that you don't have to make any trip to DC or to another agency field office. Instead, you just jump online, go to the agency's electronic reading room, and look for the documents that they have made public. A lot of times, agencies actually include frequently requested information that's been released under prior FOIA requests. They put that in their reading room because they realize that people are, really interested in something in particular. Universities, for instance, get a lot of these pouring rights contracts, which is why campuses either have Coke or Pepsi. And because public money at public universities is spent for that, the public often wants to see those contracts. So rather than continuously respond to FOIA requests for the same information, over and over, we put that information online so that people can just go ahead and view it. And if we get an open records request for that information, we can just direct the requester to the appropriate website to find it. So here is a screenshot of the EPA's electronic reading room. They break that down into different regional libraries. You'll see that for Region 8, the EPA has published various documents related to Pavilion, Wyoming. They did an investigation on groundwater contamination from fracking operations. And so many people actually submitted FOIA requests on that topic about Pavilion that the EPA made a lot of that information available in its reading room. Now, I have noticed that a lot of EPA documents are slowly going missing. I started to notice that last year when I was looking for them for work purposes, and then I really noticed it this year because I was taking notes when I was preparing the class, well, I guess starting late last year. I was taking notes to prepare this class, and I was making lists of documents, and links to those documents. And as I've gone back to try to find them again, a lot of them have disappeared. I'm assuming that this might be for political reasons, particularly when it comes to the EPA, climate change, all of that. But I was able to grab these documents. So some background, the Pavilion area had been drilled extensively for natural gas over, probably 2 decades. And it's got hundreds and hundreds of gas wells. And residents of Pavilion have been claiming for about a decade that all of that drilling, and in particular the fracking, has caused their weather to turn black, smell like gasoline. Some residents say that they're suffering from neurological impairments. They lose their smell, nerve pain. They get a lot of nerve pain that they've associated with exposure to pollutants. And Canna is the gas company that owns a lot of the wells in Pavilion, and it naturally, denied that its activities were responsible for any type of groundwater contamination. But in response to all of these complaints from the residents, saying the water's terrible, the odor's horrible, and there was also a good deal of prodding from the media, particularly ProPublica, which started reporting on Pavilion back in 2008, the EPA eventually initiated a groundwater investigation. In 2010, it actually warned Pavilion residents not to drink or cook with their water and to ventilate their homes when they showered. So obviously there was a problem with the water. And so EPA drilled some monitoring wells to get a more precise picture of the extent of the contamination. And in 2011, it issued a draft report and said, wow, these wells are incredibly polluted with chemical compounds that are consistent with those that are used in natural gas fracking. These wells contained benzene at like 50 times the level that it's safe for humans, contained other carcinogens, acetone, traces of diesel fuel. Basically, the EPA said that the water samples were so saturated with methane gas that matched the types of gas that are deep down in the earth where the fracking was occurring. The EPA also found that there were chemicals that were dumped into unlined pits, and that the barriers between those pits and the groundwater, the aquifer, were very inadequate. So then in 2013, the EPA stopped its investigation. More than likely for political reasons, because at that time, the Obama administration was promoting the expansion of natural gas extraction to reduce U.S. dependence on oil. So everything kind of ground to a halt in 2013. Keep that in mind because we will pick up on that later. So in addition to agency electronic reading rooms, the U.S. government now has this FOIA online website. Basically, it's there to operate as a one-stop shop for agency documents that are accessible under FOIA. So you can jump online, you can search for different documents, and they will come up. So here you can just see a number of FOIA requests that are currently being handled by the EPA. The requests visible here, they're all in the submitted phase, which basically means that nothing's happened yet, or the processing phase, which means the agency is working on the request. So the publication and the inspection and copying requirements, these are proactive methods for agencies to disclose information. There's also the production upon request requirement, which is a reactive method. So production upon request is actually what we typically think of as a FOIA request. If agencies haven't made information available, then members of the public, including organizations, can go ahead and request it. And then agencies are supposed to make that information promptly available, so long as the request is reasonable and it complies with agency time, place, and fee requirements. So agencies don't have to work on federal holidays. You can't hit them with a FOIA request at 2 a.m., but otherwise, if you have made a reasonable request, the agency is supposed to carry it out. Whether a request is reasonable, that is somewhat subjective. I will tell you, though, that if you request all emails sent by an agency from like 1999 to present, that's definitely going to be considered unreasonable, and you will be asked to please narrow that request. So if you're making a FOIA request, you really do want to be very specific. Specific time period, specific memos, specific email addresses. The more specific that you can be, the more likely it is that your request is going to be considered reasonable, and that you're going to get what you want. And that's really important because federal agencies handle over 2 million FOIA requests per year. State agencies also handle a significant number of requests per year. Federal agencies, since Trump became president, the FOIA requests have drastically increased. And in part, that's been due to an increase in increased lack of transparency. Sorry guys, I am getting over the flu, and talking is apparently hard today. So this is an example of a FOIA request that the Center for Public Integrity filed with the EPA early last year, early 2019. And they wanted information about then EPA Administrator Andrew Wheeler, who used to be a lobbyist for the coal industry. The Sierra Club likewise filed public records requests for documents from EPA officials responsible for the rollback of a lot of environmental rules that had been put in place by the Obama administration, mostly to combat emissions and other climate warming gases and pollutants. So when the EPA initially refused to comply with FOIA's timeline, the Sierra Club sued, saying, FOIA requires that we, the public, get these documents in a time frame where they are still useful. So the court had ruled that Wheeler had been confirmed in February of 2019, and the agency had 10 months to release the requested documents. And as you can see from the release date, which is on the right-hand side of the released records, the EPA did, in fact, release these requested documents fairly quickly. Okay, so once an agency receives a request, like the one from the Center for Public Integrity or the Sierra Club, the agency has 10 business days to determine whether or not it's going to comply with the request. That's not 10 business days to actually provide the information. It's 10 days to get back to the requester to say, yes, we are in the process of collecting your records, or no, we are not going to provide you with those records. If an agency denies the FOIA request, it's supposed to immediately notify the requester of that denial. So if the agency knows on day 1 that it's going to deny the request, it should say so on day 1, even though by law it's got until day 10. The agency also has to explain to the requester why it's denying the request, and that the requester can appeal the denial up through the agency. On the other hand, if an agency approves the request, it just has to make the information available. FOIA does not actually require that agencies provide copies, either hard copies or electronic. agencies can actually require that requesters travel to the location where the records are kept. But this is pretty rare. Most of the time, agencies will provide electronic documents. There is no fee to file a FOIA request, but agencies can charge a fee to recover some of the costs associated with processing the request. And that's because it can be really burdensome to respond to FOIA requests. The person who actually receives the request probably has to deal with multiple other units within the agency, has to review records and redact them, and all of that requires halting other work. So it can be very expensive for agencies to respond to FOIA requests, so FOIA does allow them to charge fees. So at the federal level, there are 3 categories of FOIA fees. Commercial use requesters, most of the time that's contractors who've lost a bid and they want to see the winning bid. They can be charged for any and all search time, document review, and duplication. News media, educational, and scientific requesters only have to pay for duplication after the first 100 pages, and all other requesters are charged for search time, minus the first 2 hours that are free, and then again duplication after the first 100 pages. And agencies can withhold these records until the fee is paid, which is what my agency, the University of Maryland, tends to do. Now, if an agency does not disclose the records, it's got to say why. So at that point, the agency's got 20 days to decide if the requester decides to go ahead and appeal. Under some unusual circumstances, the agency can get a 10-day extension on that. So those circumstances could be the documents are located in a different physical location and actually have to be shipped, or the agency has to search a large number of records, or consult with another agency before releasing the records. Or if it's a really old record and it's only going to be available in like microfiche or something, then obviously retrieving is going to take more time. If the requester's appeal is denied, then the agency has to let the requester know that they can seek judicial review. So they can actually go and appeal that denial in a regular Article III court. Now, there are a lot of exceptions to disclosure under FOIA. FOIA calls them exemptions. At the state level, some states call them exceptions, some call them exemptions, but they mean the same thing. And that is that the agency is not required to disclose the information in response to an open records request. Now, most of these exemptions under FOIA are permissive. So that means that the agency has the discretion to disclose the information if it falls into one of those exemption buckets, or the agency has the discretion to withhold the information. So if an exemption applies, it's really up to the agency to determine whether or not it wants to withhold the documents. FOIA permits agencies to disclose a certain amount of private information, but the Privacy Act, which we're going to discuss later, prohibits agencies from disclosing any private information about individuals. So even though FOIA technically allows an agency to disclose like your home address, your social security number, things like that, in practice, that information is protected by another law. And if somebody makes a FOIA request and the agency refuses to disclose that information and then gets sued, the agency is actually the one that's got the burden of proof. The agency's got to prove that the information that it withheld is properly covered by a FOIA exemption. So this is a list of FOIA exemptions. These are pretty much all geared towards keeping sensitive information safe. And I'm going to discuss the exemptions that are most relevant to environmental and emergency response agencies. If you want more information about the other exemptions, just post a comment, post on the Q&A discussion board, and I'm more than happy to talk about these other exemptions. Okay, so the first important one for our purposes is the critical infrastructure exemption. This is a new exemption in the life of FOIA. All of the other FOIA exemptions have been around since FOIA became a law, but the critical infrastructure exemption was created after the September 11th terrorist attacks in 2001. This exempts from disclosure any data that owners and operators of critical infrastructure have voluntarily given to the government. and this includes private infrastructure. So a lot of times, government contractors, or even not government contractors, but facility operators that are being regulated, have to provide certain information to the government. And that is no longer available for disclosure under FOIA. So this applies to communications like cell phone networks, landline networks, internet providers. It also applies to banking, healthcare, utilities, in particular the electrical grid. And the reason for this exemption is that the federal government wanted to ensure cooperation from its private contractors. These contractors were very sensitive to the possibility that once they gave their information to the government, it could be disclosed under a FOIA request. So the government wanted to make sure that government contractors who work in critical infrastructure were willing to cooperate and help the government respond to threats to our infrastructure. And the best way to get that cooperation from private parties is to promise that that information that they give to the government won't be disclosed under FOIA. And these contractors are primarily concerned, with their confidential business information. They don't want that disclosed to their competitors. There is an exemption for situations where another law prohibits disclosure under FOIA. So while FOIA presumes openness and disclosure, some statutes actually require that agencies withhold information. FOIA does not need to specify the names of those statutes. Basically, whenever another statute says, hey, government, you've got to withhold information, then it creates a FOIA exemption. So it's actually surprisingly common for statutes to require that agencies withhold some information. So for example, I've got this to the right here, I've got a part of a statute. This is from 7 U.S.C. section 4608, and that exempts certain information about honeybee handlers. So if you were to file a FOIA request with the USDA about honeybee handlers, the agency would deny that based on this particular statute. And a lot of the information about the Honey Board, which holds an annual meeting in Denver, is similarly exempt from disclosure. In this particular case, the statute exempts this information because of the fact that honeybees are crucial to our environment and they heavily impact agricultural operations. So if somebody submits a FOIA request for information about honeybees or their handlers, the agency's got to deny that request. Similarly, you've got the trade secrets and financial information exemption. This is actually one of the most frequently invoked exemptions, and it applies to trade secrets and other commercial and financial information that agencies obtain from private parties. What this is really aimed at is making sure that the government doesn't disclose any competitive information that could result in harm to the private party or impair the agency's ability to get that same type of information in the future. So if a private party thinks the government's going to disclose its confidential information, they're a lot less likely to willingly hand that over to the government, and then that can seriously impede the government's ability to function. So this is why agencies are not supposed to disclose trade secrets. The entire point of that is that it is secret. The moment it is no longer a secret, the company can't protect the information. So for instance, if the USDA knows Coca-Cola's secret recipe, it's going to withhold that from disclosure. Otherwise, Coke is going to sue the heck out of the USDA. There are some times when agencies decide that they are going to go ahead and disclose company trade secrets or confidential or financial data. And when that happens, the owner of the information, typically a company, sues the agency to prevent it from disclosing. And that is what we call a reverse FOIA suit. So if it is successful, a court will just quash the agency's disclosure, and that information is going to remain confidential. There are some other relevant exemptions for our purposes. Those would be personnel files and geological information. So personnel files, obviously, all agencies have them. The exemption for them is fairly broad. It applies to records that contain personnel information, and that also includes some medical information or general private information. So agencies withhold from disclosure any type of files that would reveal personal information about an employee, other than salary, because as the public, we pay the salary for our government employees, so you can generally find out how much somebody makes. But if you were to ask for the home address or personal phone number of a government employee, you're not going to get that because of this particular exemption to FOIA. Also, confidential HR records, things like disability accommodation paperwork. That is all, agencies will err on the side of caution, and they're not going to disclose those records. There's also a geological information exemption that lets agencies withhold certain information basically about water wells and aquifers. And the purpose of this one is to protect the nation's aquifers, basically so that terrorists can't poison them or cause some other type of harm to our drinking supply. So that's the structure of FOIA and how it was intended to operate. And now we're going to briefly turn to how FOIA actually operates today, because FOIA is very susceptible to presidential influence. So after the Watergate scandal, Congress wanted to strengthen FOIA to favor more disclosure. And then President Gerald Ford was very agreeable to this. However, Ford's chief of staff, Donald Rumsfeld, and his deputy chief of staff, Dick Cheney, persuaded Ford to veto that bill because they were concerned about the potential for leaks of secret information. Now, Congress was able to override that presidential veto, and to offset concerns about security, Congress did provide an opportunity for judicial review of any executive branch claim of secrecy. So after that, there was a bit more accessibility to government records. Then the Reagan and George H.W. Bush administrations once again narrowed FOIA disclosures by allowing agencies to withhold pretty substantial amounts of information pursuant to FOIA's national security exemption. But both of those presidents did have to issue executive orders requiring non-disclosure of that information. So even so, though, this was a fairly broad decision to withhold a lot of information from the public. Then when Bill Clinton was elected, his administration swung that pendulum in the other direction and expanded disclosures under FOIA. And Clinton also permitted the release of national security information that had been withheld by previous administrations, as long as those records were at least 25 years old and of historic interest. So during the Clinton years, we saw an increased presumption of disclosure under FOIA. Then George W. Bush got elected, and again, the pendulum swung the other way. So the Bush administration started restricting these FOIA disclosures. That actually started prior to the September 11th, 2001 terrorist attacks, but really ramped up after those attacks. So the Bush administration reversed the Clinton administration's decisions and specifically restricted the disclosure of records of former presidents. Then, after Obama was elected, he almost immediately revoked Bush's restrictions, and he issued an executive order encouraging transparency, openness, and accountability. So after Obama was elected, there was an expectation among FOIA watchers that the Obama administration was going to be really transparent and agree to disclose large amounts of information. And as a whole, the Obama administration was better about transparency than the Bush administration, but it was not nearly as transparent as people had hoped. In fact, an Associated Press analysis showed that people who asked for records under FOIA received either redacted files or nothing in 78% of these requests. And it was well over 800,000 requests. And when the government provided no records, it said it could not find any information related to the request about half the time. And so again, this is the Obama administration. Then the Trump administration, in its first year, censored, withheld, or claimed it couldn't find records really more often than at any other point in the past decade. And keep in mind that in that past decade, the government was withholding a lot of records anyway. That same year, the first year of the Trump administration, the federal government spent around $40 million in legal fees defending its decision to withhold federal files. And so that amount spent is also a record. So the unfortunate reality is that the Obama administration was not great about FOIA disclosures, and the Trump administration has not been any better. And under Obama, at first it was difficult to determine whether this was an actual concerted effort by the administration to withhold information or just something that happened due to high turnover and lack of training. But it turned out that the Obama administration did lobby Congress quite strenuously to avoid disclosing information, and that was the opposite of Obama's stated desire for openness and transparency. So lest you think I only pick on the Trump administration, I don't. The Obama administration had plenty of problems, and the Obama and Trump administrations share these FOIA problems. So the reality of FOIA today is that almost no agency actually gets you the information within the required statutory period. It really takes a lot of effort to get information out of a federal agency pursuant to a FOIA request. So for instance, FEMA, when asked for information about its responses or lack thereof to Hurricanes Katrina and Sandy, FEMA took an average of over 200 days to respond to requests. And that's just an average. There were plenty of times where it actually took over 500 days. The processing time across all federal agencies for even real simple requests is over 100 days. As an example of a simple request, at work on behalf of my university, back in November of 2018, I submitted a FOIA request for a specific contract that was issued to a specific company. So only my university and this other company had submitted proposals. As required, the agency sent my university a letter stating that, its proposal was not successful, and the letter named the winning company, the name of the federal contracting officer with contact information, the federal contract number, and the date the contract was issued by the contracting officer in a specific office within the agency. So I provided all of that information to the agency FOIA officer as part of my FOIA request, and I made it really clear that all I wanted was a copy of the contract, the specific contract for which I had provided the contract number, the date of issue, and the name and contact information of the contracting officer. So that was back in November of 2018. In February of 2019, I got a letter from the agency saying that my request was, quote, very complex and, quote, will require significant interagency action to process. So that's entirely untrue. It was a request for a single document issued by a single agency with contact information for the agency person who issued it. And while I have followed up many times in writing, I have only received a single follow-up response. That was in June of 2019, at which point the agency basically told me that it had a backlog of about 11,000 FOIA cases, and it would get to me when it gets to me. So FOIA is supposed to make it easy to get government documents, and sometimes it does, but more often it does not. Now, to be fair, the lack of disclosure doesn't necessarily stem from the government's desire to keep records secret. A lot of these documents that are requested pursuant to FOIA, they don't actually contain any information that would be a huge surprise to the requester. So it's not necessarily a desire to keep things secret, but it is often due to the fact that a lot of FOIA offices are just not staffed properly. So this is the same with procurement offices. People retire, they don't get replaced, and that puts a strain on the whole system. So if you've only got one or two people responding to FOIA requests for an entire agency, say the Department of Defense or the Department of Homeland Security, there's just going to be a huge backlog. And that is where we find ourselves today. So agencies are not supposed to just ignore FOIA requests. There are a number of checks on agency discretion. So if you submit a FOIA request to an agency and it's denied, or more likely you just don't ever hear back from them, you can go ahead and file a lawsuit, much like the Sierra Club did when it could not get records. FOIA specifically provides for judicial review, so you can sue in federal district court. The court's going to examine the request de novo, so on its own, it doesn't matter what the agency said, and the agency's got the burden of proving that a document is exempt. If the court feels that the agency failed in its FOIA obligations, it'll order disclosure of records, it'll hold the agency in contempt, and it can even award attorney's fees and costs to the requester. There is also the Office of Special Counsel, so it is an independent investigative and prosecutorial agency. So it can initiate disciplinary investigations against agency employees who kind of arbitrarily withhold records. And the special counsel can force an agency to follow its recommendation about disclosure under FOIA. And then in addition, agencies have to submit yearly FOIA requests to Congress, talking about the number of FOIA requests they refused, number of appeals that refused, etc. So there are these checks on agency discretion. Okay, so as we've seen, agencies are allowed to collect information about people, to accomplish their statutory mandates. If you think about it, like right now we're in tax season, just think about all the information you give to the IRS. Your name, your address, your phone number, your marital status, your income, your occupation, your parental status, your investments, do you own a home? What are your medical expenses? What kind of charitable giving do you get involved in? All that information goes to the federal government. And the Privacy Act exists to make sure that the government can't simply disclose that private information, particularly in response to a FOIA request. So like FOIA, the Privacy Act is part of the Administrative Procedure Act. It withholds sensitive documents from public disclosure. Its purpose is to protect the privacy of records that are compiled about individuals. So actual natural persons. It does not apply to organizations. But records are really any type of information maintained by an agency about an individual. So that could be education records, financial transactions, medical history, criminal history, employment history, everything that agencies collect on us. And the Privacy Act prohibits disclosure of those records unless the agency obtains the consent of the individual, or unless the record falls into a Privacy Act exemption. So the Privacy Act, it doesn't actually apply to very many records because most records are not about individuals. Most records are about organizations. But in any event, in practice, the Privacy Act converts FOIA's discretionary non-disclosures into mandatory non-disclosures. So FOIA might allow an agency to decide whether or not to disclose records, but the Privacy Act actually just kind of takes that discretion away and says, nope, you are not allowed to disclose those. The Privacy Act also requires that agencies that are collecting information about us maintain that information lawfully, consistently, and accurately. Like FOIA, the Privacy Act requires reports to Congress, although those reports are a little bit different. It also allows individuals to seek judicial review if an agency refuses somebody's request to correct information in a record about them, or refuses to grant access to an individual's own records, or if an individual is harmed for some reason because of the agency's failure to properly maintain records. So in response to a Privacy Act lawsuit, a court can order that the records be amended for accuracy, order that the records be turned over to the individual about whom the records have been collected, or totally prohibit the disclosure of records at all. And unlike FOIA, the Privacy Act imposes criminal penalties on government officials who disclose private records. So there's two penalties that apply to the government, misdemeanors with up to a $5,000 fine, and then also there's a penalty that applies specifically to individuals who are making requests that they know, basically making requests under false pretenses to try to gain information that the Privacy Act prohibits agencies from disclosing. Okay, so that was FOIA and the Privacy Act. The third of the big three is the Government in the Sunshine Act, often just called the Sunshine Act. So it is actually based on Madison's Federalist Paper number 49, which was called Method of Guarding Against the Encroachment of Any One Department of Government. So this is also part of the Administrative Procedure Act, same as FOIA and the Privacy Act. It applies to agency meetings only. And in fact, it applies to what we call collegial agencies or boards within agencies, and those are headed by more than one person. So it covers about 55 different agencies. And it basically just requires that agencies give a week advance notice of meetings and that the public be allowed to attend those meetings. So a meeting is a gathering large enough to fulfill quorum requirements so that an agency can take legal action. These meetings have to involve a deliberation of agency business, so that can be formal agency action, significant discussions about agency business, things like that. Now, not meetings that are just part of informal background discussions, because we do want our government officials to be able to meet and talk informally and candidly. So meetings aren't every single meeting of government agencies. It's these ones where you're actually going to involve or have a significant discussion of agency business. Like FOIA, meetings are presumed open. There's this presumption of openness in the Sunshine Act, and meetings can only be closed if an exemption applies. Now, again, those exemptions are permissive. Agencies do not have to close meetings. Additionally, there can be separate statutes that override the exemption and require that agencies keep certain meetings open. If they do close them, they've got to have a reason for closing them and certify that. And they also need to make a complete audio record and transcript. So if it's a closed meeting, there's got to be audio and there's got to be a transcript. And like FOIA, like the Privacy Act, there's congressional monitoring, and there is also judicial review, in which case, if you're successful, the court can order injunctive relief so an agency can't close meetings in the future. It can also order the agency to provide that transcript or audio of a closed meeting, and it can award attorney fees and other litigation costs to the individual. So in addition to the forms of public access that were granted through the Administrative Procedures Act, there are other statutes that require the public disclosure of information. And one example is the Emergency Planning and Community Right to Know Act of 1986, which encourages and supports emergency planning efforts at the state and local levels. And it also provides the public and local governments with information concerning certain hazards that are present in their communities. So the Act requires the establishment of state and local emergency response teams, comprehensive emergency response plans, things like that. But where it matters for public access is the requirement that certain information that entities that use hazardous substances have to disclose. So upon request, we as individuals can basically just go to the local emergency planning committee and request some of this information, particularly like material safety data sheets. And that committee either discloses them or it goes to the facility owner or facility operator that's, for instance, running the industrial plant that creates chemicals or uses chemicals, and basically tells them that they've got to provide this information. The regulations that come under this act establish various reporting requirements for providing the public with important information on hazardous chemicals. So the public can, access this information. Companies are also required to report this information to health professionals upon request. So basically, doctors, nurses, and such can ask companies for information about their hazardous substances if that healthcare professional needs it to diagnose or treat somebody, if there's been an exposure to chemicals, which I guess really does fit under diagnose and treat, and then if knowledge of the specific chemical identity will assist in diagnosis. So in that case, there is no trade secret exemption. A company can't claim a trade secret in its, proprietary chemical compound and withhold that from healthcare professionals. It can keep it a trade secret by requiring those healthcare professionals to enter into a confidentiality agreement. but it can't, privilege its trade secrets over the lives of actual human beings. Under the Emergency Planning and Community Right to Know Act, citizens can actually sue owners and operators of facilities that use hazardous chemicals if they are not providing these data sheets, inventory forms, toxic chemical release forms, and other items that are required by the statute. Citizens can also bring suits against the EPA administrator for failure to publish information or failure to take other steps that are required by statute. In addition, citizens can sue state governors and state emergency response commissions if they don't provide a mechanism for publicly, divulging information required by the law. And finally, the statute also allows state and local governments to sue on basically the same grounds as citizens. Now, a word about government contractors with public access. Private parties that are performing governmental functions or receive government funding. So if they're performing functions, they're contractors. If they're receiving funding for some other reason, they're probably grantees. Or if they're acting under any type of authority from the government, those private organizations might be subject to openness requirements. Courts will look at the extent to which the government manages the daily operations of the organization, regulates the organization, funds the organization, the amount of authority that the government has delegated to the organizations. Is the organization performing a core government function, which we will soon learn they're not supposed to do? And then basically just any other time when members of the public could reasonably assume that the government was carrying out these functions, not a contractor. And speaking of government contractors, now we are going to jump over into our discussion of privatization. So delegating to private entities has a bunch of different names, but it's all the same concept. We call it contracting, outsourcing, procurement, acquisition. Now, when we are talking about outsourcing, we're discussing government agencies that are outsourcing to private companies. So not to a case where a company outsources to a non-US location. So government contracting has been around for quite a long time. Here you got a picture of a request for proposals for the bricks to build the Capitol building. This is from 1816. But government contracting has actually been around for far longer, and it's got its background in military and empire building operations. So it's been around since ancient Rome, actually further than that, but for the Western world, ancient Rome. It's been in China and India and probably Egypt prior to that. So in ancient Rome, the Senate had to supply its outposts and military as the Roman Empire grew, and it realized that it needed a procurement system. And so England then eventually sort of created a system of military procurement that had been based on the Roman system. And then the English system was actually adopted in the American colonies before the American Revolution. So during the American Revolution, the Continental Congress, because keep in mind, this was before we had the Constitution, the Continental Congress did not have the authority to tax colonies or pass any type of binding laws. And naturally, this created quite the issue for the war effort. So there were these quartermasters who were responsible for acquiring and distributing goods to help the war effort, but they had no ability to obtain funds, so it was really hard to make purchases. They also had many different layers of purchasing agents who reported to the quartermasters and who readily took bribes and awarded contracts to their family and their friends. Eventually, the Treasury Department kind of came up as a centralized purchasing authority. There's actually a Philadelphia merchant named Robert Morris. He overhauled the system. He started requiring invitations for bids. He started requiring that contractors be responsible, and he also required contract terms that benefited the public. So once the U.S. Constitution created a stronger federal government, Congress wanted to increase competition for contracts. But it set up a system that allowed for advanced payment to contractors, and this was because of westward expansion. Congress needed contractors to head west. But this system failed because a lot of contractors were very happy to take the money but not deliver the goods, and they were pretty far away from Washington, D.C., so they felt they could get away from that. Actually, the first government contracts dispute in U.S. history deals with Eli Whitney of cotton gin fame. Bottom right is his contract. So he actually wasn't making any money for inventing the cotton gin, so he decided to get government contracts and manufacture muskets for the new U.S. Army. It took him 8 years, and he basically delivered rifles that didn't work. And that was the first U.S. lawsuit over a government contract. Whitney, unintentionally, introduced concepts of overhead and cost accounting that I won't get into, but if you work too long in any type of agency, you'll probably at least hear about them. And then throughout westward expansion, modern contracting processes and practices evolved, including the use of good faith estimates, and also government furnished materials. So in particular, the government was furnishing cloth to military contractors to go ahead and make uniforms out west. Then we had the Industrial Revolution, where contracting procedures evolved along with manufacturing techniques. So as manufacturing improved, so did the procurement system. Congress decided that government officials could not personally benefit from contracts. Congress implemented some formal advertising requirements, required agencies to contract with appropriated funds, and the Army issued general regulations that are the precursor to today's federal acquisition regulations. Now, unfortunately, the Civil War stressed our procurement system to the point of breakdown, and the military just kind of started ignoring contract requirements. So we went back to bribery and nepotism. And then in congressional investigations after the Civil War led to the passage of the False Claims Act. And Congress decided, okay, contracts have to be in writing, they have to be signed by both parties. And it was after the Civil War that our modern procurement system really started to develop. So through, about the end of the Cold War, definitely throughout the World Wars, the government mostly relied on military contractors to handle things like basic camp services or to manufacture equipment, tanks, weapons, things like that. As computer technology really started to develop during the Cold War, the government also started hiring IT service contractors. Today, unfortunately, the military isn't relying only on those traditional types of defense contractors. It is really wholesale outsourcing military services, and we will discuss that in more detail shortly. But I want to talk about the importance of government contracting, and it's important in part because it's just everywhere. I mean, it is throughout the federal and state governments, local governments, everywhere. So before we invaded Afghanistan, the federal government spent over $200 billion a year on government contracting. At the height of the Iraq War, it was spending $537 billion per year. Now the government spends just around $508 billion per year. So every agency contracts with private companies. Overall, we've got 300,000 contractors, those are the companies, and around 8 million contractor employees throughout the federal government. So you can see towards the right-hand side of the screen, that's the EPA in orange. It spent $1.5 billion on contractors in FY 2018. So government contracting is one of the main reasons for court cases. A lot of times the government and contractors will sue over didn't get a contract, got a contract but didn't perform it properly, got a contract, performed it fine, but the government didn't pay properly. So these are the main reasons that agencies wind up in court. And more worryingly, agencies like the DoD and Homeland Security are really operationally dependent on contractors now, which is why it is such an important topic to understand. So what does the government buy? I mean, the short answer is all kinds of stuff. So I've got here on the screen images from NASA's Cassini mission, that's the launch of the photo of Saturn. There is a tsunami detector by SAIC. We've got fighter jets and ships. The city of Denver bought some purple gorillas. I don't actually know why, other than the fact that Denver likes large animal sculptures, although in that case, they should really be blue gorillas. Government buys everything from like pencils and milk to whole buildings and space shuttles, although not space shuttles anymore. So government buys things that range from incredibly simple items that are usually just purchased from the lowest bidder to incredibly complicated, complex items that are usually purchased from the best overall offerer, not just on the basis of lowest price, which is good because we don't necessarily want our military jets to be, the cheapest ones that we could get. We want them to be the best ones that we can get. Now, the power to make purchases is not actually in the Constitution. The Constitution is silent as to the federal government's ability to buy goods and services. That said, all of the powers that are enumerated in the Constitution would be completely useless without purchasing power, because the government can't carry out its powers and duties without buying at least some goods and services. And, the Supreme Court recognized in the 1800s that purchasing power flows down to the individual agencies, but did note that every purchase has to be traced back to authorizing legislation, basically permits the agency to buy things, and appropriations legislation that provides the actual funds. So, prior to 1994, we all agreed that the government needed to buy stuff because the government lacks expertise in, particular areas like running a dairy or creating pencils or building ships or providing IT services. We also recognize that the government might need additional help when responding to emergency situations, so it might call on contractors to provide supplies and support personnel. There is an understanding that the private sector is often more efficient than the government, particularly when it comes to producing goods. The government doesn't need its own manufacturing plants to make pens and cars and ships. But they're not always more efficient. Now, for day-to-day services, custodial services, things like that, there have been studies that do show that the private sector is more efficient for the government. But in many ways, in particular military and correctional services, it's actually more expensive to outsource than to have the government provide services. But everybody agreed that we needed a procurement system. So we operated under the old procurement system prior to 94, and the old procurement system was absolutely full of gobbledygook government speak. So for example, here is a GSA solicitation from 1993. I only have a little part of it here. This actually went on for 9 pages. So here's part of the solicitation. Type 1 glass square 4.5-inch ash receiver that includes several features: minimum of 4 rests, spaced equidistant around the periphery and aimed at the center of the receiver, molded into the top, sloped towards the center of the receiver. It goes on about how things need to be parallel, that the surfaces need to be smooth. Then the receivers must be tested for defects by placing the specimen upon a solid support, in this case, a 1 3/4-inch maple plank, placing a steel center punch, point ground to a 60-degree included angle, in contact with the center of the inside surface and striking it with a hammer in successive blows of increasing severity. Okay, so this language went on for 9 pages. And what did they get? They got glass ashtrays. Actually, they got expensive glass ashtrays because there was no company manufacturing ashtrays for commercial sales that tested ashtrays to this extent of minute detail. So this was a terribly inefficient system. Fortunately, we moved to a new procurement system in the 90s. So the new procurement system was really all about Al Gore. Now, The media didn't focus on it because it's just not really a sexy topic. But Al Gore created a task force. It was the National Performance Review, later renamed the National Partnership for Reinventing Government. And this task force radically reconfigured federal government procurement. It proposed 1,200 changes to better serve its customers, meaning government agencies and also the public. It simplified the whole system so that we didn't need 9 pages of blather to buy ashtrays, although by that time I don't think we were buying ashtrays for the feds. It got rid of all these unnecessary regulations and requirements that were burdensome to both businesses and government agencies. It fostered competitiveness by bringing in commercial practices. It encouraged plain English documents. Although as somebody who constantly works with federal regulations, I would say they're not quite in plain English, but that gives me some job security. The task force under Gore encouraged the use of technology to widen access to federal services and information, including it spearheaded electronic tax filings. So if you do your taxes electronically, you can thank Al Gore and his task force. It also implemented performance metrics so that we could evaluate and hold agencies and contractors accountable. It really sought to empower frontline workers by giving them more leeway to purchase commercial items. It actually created a simplified acquisition scheme for commercial items. Basically, it was a free market system designed and implemented by a Democratic policy wonk. Now, this wasn't all good. I mean, I think that the new procurement system is leaps and bounds better than the old one. However, it had some unintended consequences. The biggest one really was that we lost a lot of bench strength. So particularly in Pentagon acquisition, there just weren't as many government employees to do the work. And that damage remains visible today. When W. Bush came into office after Clinton, the Bush team really didn't like the internal bureaucracy. It really favored outsourcing, and so a lot of those reinvention efforts were undone. For instance, one of them was the overhaul of FEMA that led to widely criticized response to Hurricane Katrina. Now, fortunately, at the working level, reinvention of government has actually continued on regardless of presidential administration. There was a quote that said, "It's like getting hospital workers to wash their hands." You know, there's just been this fundamental change in the understanding. People don't go back to not washing their hands in hospitals, they just kind of start doing it, and that's the same that has happened. Reinventing government has kind of created a sea change within government acquisition. So Gore's task force set forth fundamentals of government contracting, saying it's got to be competitive, accountable, and transparent. So in order to have true market competition, you've got to have conditions that are either known or mostly foreseeable. So the government's got to have well-defined needs. It's got to be able to effectively monitor performance, because that actually helps businesses make more informed decisions about what they want to bid on and how much they want to charge. So the premise of outsourcing is that a competitive environment is going to reduce costs. This is happening in many areas. It is unfortunately not happening in the military and corrections areas, because the costs of using military contractors and correctional contractors actually tends to be higher than just using government people. So when you hear about government contractors in the news, it's usually because something's gone wrong, or there's been some hot topic like waste or fraud. I will say that having worked in the government contracting field for my whole career, most of these government contractors do a great job day to day. But again, it's just not really a sexy topic for media coverage, so we only hear about the problems. It does, as a government contracts attorney, drive me nuts to hear about how terrible our system is and that we need to overhaul it, because our system is actually really good. Gore's task force did a great job of overhauling the procurement system. They really thought through a lot of the issues and streamlined the process. So the policy that underlies our federal procurement system is really sound. The problem comes at the implementation stage. Like so many things in government, it's the implementation stage that is more challenging. Additionally, our system is facing a lot of problems due to that lack of institutional knowledge and lack of bench strength. Since Reagan was president, Layoffs, retirements, hiring freezes, all of that has resulted in a shrunken and weakened federal acquisition workforce. So we actually don't have enough people to oversee the contracting process, but that contracting process is not going to stop anytime soon. So fortunately, we do have some limits on agency contracting discretion. We've got procurement and acquisition laws that really do serve to limit agency discretion in this area. So there is appropriations legislation, which is how Congress gives an agency funding. If Congress gives funds to NIH, National Institute of Health, and says you've got to use this for cancer research, then NIH has got to use those funds for cancer research. There's also the Anti-Deficiency Act, which we've talked about, says that nobody can obligate the government to make payments without appropriations legislation. This is why federal contracts are issued in 1-year increments. That's because Congress only appropriates 1 year at a time. We hope. Sometimes they don't even do that. But that's why you only get 1 year of a government contract. Even if it's 3 years, you're only guaranteed that first year. There are also regulatory limits established by the FAR. And there is a doctrine that says that core governmental functions cannot be outsourced. When contractors are used, they're supposed to serve the public interest. But if you think about privatization of prisons and military contractors, in my opinion, I think that we are outsourcing some of these inherently governmental functions. But the public has a right to expect prudent spending, and so that is why government contracts are supposed to be heavily regulated to ensure transparency and accountability. And that's where these limits on agency contracting discretion really come into play. So we have a huge range of contractors, from one-person small businesses to gigantic pharmaceutical and defense companies. Government contractors include companies, nonprofit organizations, NGOs, universities, even state agencies. And those contractors typically break down into contractors who provide services and contractors who provide equipment and other goods. So in traditional personal services contracts, the government retains the function, but the contractor personnel just staff the effort. And traditional service contracts provide things like IT support, research, facilities and maintenance operations, food service, things like that. Traditional industrial contractors, they handle large-scale building and manufacturing, so anything from making uniforms to building aircraft carriers. And we as the public, we benefit from having these big companies like Boeing and Lockheed compete for government contracts, because we are benefiting from not having to pay for the building and maintenance of these giant manufacturing facilities, because that's very expensive. So it's sort of a good setup that we can have private companies or private organizations build those, and then the government can take advantage of them with taxpayer dollars. Now, though, defense contractors have a new role in our sort of new military-industrial complex. So back when President Eisenhower, he made his famous statement about the dangers of the military-industrial complex, he was thinking more about traditional service and industrial contractors. His concern was that the federal government wouldn't provide appropriate oversight, and the country would find itself in a situation where big contractors pushed us into wars, because wars are very profitable for certain companies. It's actually worse than that now, because our new military-industrial complex is far more invasive, and that's because it places contractor personnel on the front lines, and that might be a physical battlefield, or they might be piloting unmanned drones from thousands of miles away. Now, until the late 1700s, nations typically did pay mercenary firms to fight wars. So if you kind of think of like Game of Thrones, you have the Second Sons and the Golden Company. Those are mercenary firms, and they were fighting for political powers. And in fact, during the American Revolutionary War, the British relied really heavily on Hessian mercenaries to fight the American colonists. But after the American Revolution, there was a shift in thinking, and this idea emerged that a citizen should fight for his or her country and not for anybody else. So if you are going to go to war, you should do it for your country, not as part of a mercenary company. Now, though, we find ourselves in a situation where the US and other countries have begun outsourcing what, to me, are clearly inherent government functions because they relate to military and intelligence activities. And this isn't just about mercenary soldiers. General Dynamics, for instance, won a $10 million contract from U.S. Special Operations Command's Psychological Operation Unit to create websites to influence foreigners' views of U.S. policy. It's kind of similar to the Russian troll farms of today. And we also now see both federal and state governments relying on contractors to assist in the aftermath of disasters. That part is reasonable. You do need to kind of have all hands on deck to respond to disasters. What is not so reasonable is the fact that the government often overlooks local contractors and thus overlooks the opportunity to inject some much needed money into the local economy. So as we saw in one of this week's readings, after Hurricane Maria hit Puerto Rico, about half the federal agencies involved in the cleanup effort did not issue a single contract to Puerto Rico-based contractors. And that's even though the Stafford Act mandates the use of local firms in the recovery and reconstruction process. So I, as a government contracts attorney, am very supportive of government contracting. In general, I think it's a very good idea. But I also think that we have gone a bit overboard lately, and we either need to rein it in or at the very least have a public discussion about it. Because overdependence on contractors has been a big concern for a while. And it's a concern because we're no longer certain that our bureaucracy can survive without contractors. We know that we have a problem with hollow agencies. These are agencies that rely heavily on non-federal personnel to run them. Department of Homeland Security is a big hollow agency. And even though this week's readings about dependence on contractors are a few years old, the situation has not improved since then. It's actually gotten worse. Oversight challenges are another issue. Many agencies now rely on contractors to oversee other contractors. And in part, it's because the sheer number of contractors make government oversight difficult, if not impossible. It's also difficult when you've got, military or intelligence contractors or contractors who are working to rebuild in areas that are hit by natural disasters, because it's very difficult to provide effective oversight in the field, particularly if it's dangerous. A contracting officer who works in an office in Washington, D.C. simply doesn't get the opportunity to travel around and get eyes on the contractors that are in his or her portfolio. There's also concern about effective public service in a profit-driven model, as well as ethical considerations like the undue influence that contractors can have on public policy. So for example, private military services industry is so intertwined with service and support components of the U.S. military that the U.S. military feels that it would pretty much have to rebuild from scratch in order to do without its contractors, and it would have to reinstate the draft. And the same is true in other fields. So we have these increasingly powerful large companies that are not accountable to us as the general public, but do have an impact on public policy. So one example, one of the reasons that Medicare and Medicaid can't really negotiate drug prices is because big pharmaceutical companies who are contractors who provide drugs to the federal government have really fought that. And the larger the contractor, especially in the pharmaceutical, military, and aerospace industries, the more influence they have in Congress, at the Pentagon. Contractors become very integrated into the government, and then they use their growing political leverage to make more money. Now, for companies, making money on its own, that is not a problem. Companies exist to make money. The problem arises when that money is based on the sacrifices of regular people. Private military contractors require pretty much constant war to make a profit. And constant war means many lives lost. American troops, civilians, looking at maybe the private prison industry, contractors who run prisons, they don't have any incentive to rehabilitate prisoners. They do have an incentive to lock up as many people as possible, which also destroys lives and communities. So there is a conflict of interest inherent in government contracting. The government is supposed to be accountable to the people. Businesses are supposed to be accountable to their shareholders. We have not had an appropriate discussion of this inherent conflict. And so in part, I think the American public hasn't ever really had a real debate over whether extensive outsourcing is a good thing, in part because the public doesn't understand the magnitude of contractor use. You generally only hear about it due to newsworthy incidents. But we use a lot of contractors. The Department of Defense employs about 1.4 million military personnel and about 770,000 civilian personnel. It's also got part-time reserve personnel. So it knows how many military and civilian personnel it employs. It does not know how many contractors it employs. It estimates around 750,000. But 10 years ago, back in 2010, then Defense Secretary Robert Gates made what he called a terrible confession, which was that he, the Defense Secretary, could not get information on the number of contractors who worked just within the Office of the Secretary of Defense, not the DoD as a whole, just the office that provides civilian leadership that the Secretary of Defense oversees. So the fact that the DoD does not know its number of contractors is disturbing, because how is it supposed to provide oversight and accountability? Similarly, the NSA and other intelligence agencies have noted that if they had to give up their contractors, they couldn't function. Private contractors working for the CIA have recruited spies in Iraq, paid bribes for information in Afghanistan, protected CIA directors visiting, various cities around the world. Contractors have snatched suspected extremists off the streets of Italy, interrogated detainees at secret prisons, watched over defectors who were holed up in the Washington suburbs. At CIA's Langley headquarters, contractors are the ones who analyze terrorist networks. And at the CIA's training facility, contractors are the ones who are helping to mold a new generation of American spies. And we have not discussed whether or not that's something that we want to outsource to companies. Do we want our government to give up those functions? There are also massive oversight challenges for government contracting. Like I said, there's been a significant reduction in the federal acquisition workforce, so a single contracting officer in an agency will deal with hundreds or more likely thousands of contracts a year. There are inadequate resources. There's the lack of institutional knowledge really means that mistakes are repeated. And like I said, we're relying on contractors to oversee other contractors because it is hard to monitor performance in wartime environments, natural disasters, or even unusual circumstances like the BP oil spill. So a big oversight challenge has been that expediency has taken priority over good contract administration. The GAO report, speaking of mistakes that are repeated, there's a GAO report about the DoD, and it states that, even though the DoD's got over 10 years of experience with logistics support contracts, it keeps making the same mistakes in new deployments. Ineffective planning, inadequate cost control, insufficient training, just a pattern of recurring problems that make it very challenging to engage in good oversight. There are also ethical concerns. So think back to when we were discussing FOIA earlier, that EPA Region 8 Pavilion thing. Okay, so the EPA made its draft report public in 2011. And that study really ticked off some senators in Congress. And actually, based on some correspondence that was obtained under FOIA, there were some senators who were demanding repeated briefings from EPA officials on fracking initiatives, basically just dragged down the EPA about questions on its expenditures over in Pavilion, Wyoming. You know, how many dollars did it pay for a lab to check the water samples, things like that. Wrote reports to the EPA, told the newspapers that the EPA's report that concluded that fracking was polluting the drinking water was totally unsubstantiated. You know, there was an effort to destroy hydraulic fracking, things like that. So in 2013, the EPA just basically retreated from the Pavilion investigation. They just stopped. And it really shocked everybody. It shocked environmentalists, it shocked energy industry folks, but the EPA handed that study over to the state of Wyoming for a state study, which just so happens to be funded by Encana, the drilling company that caused or likely caused the contamination. So ethics in government contracting is always a big deal, and it's been an even bigger deal since the Trump administration. So you might remember hearing about Whitefish Energy Holdings that won a sole source $300 million contract to restore Puerto Rico's electrical grid after Hurricane Maria. That was canceled due to a controversy. So usually, if you've got a major blackout, loss of electricity of some sort, governments, local, state governments have these mutual aid agreements with U.S. utility companies. So those companies send crews, minimal cost to restore power. That did not happen in Puerto Rico. Instead, Whitefish Energy got the money. Whitefish Energy was the one who contracted with these public utility crews and then vastly overcharged the feds for that labor. So something that the federal government could have gotten, or the Puerto Rican government for that point, could have gotten relatively cheaply based on pre-existing relationships, instead paid a lot more for that. Whitefish Energy also had a tie to Interior Secretary Ryan Zinke. This was one of the many investigations. So Interior denied that Zinke helped secure that contract, but it was a real big concern because Congress learned afterwards that the company only had 2 full-time employees when Puerto Rico was decimated by a hurricane. FEMA, said that it hadn't reviewed or approved the contract. Contract had stuff like $300 an hour for site supervisors, which is a lot more than we would normally pay. And so, based on this contract, Whitefish Energy charged Puerto Rico more than double the regular wages, charged higher than normal daily meal rates, really struggled to get equipment to the island, forced, the Puerto Rican government to hire some expensive charter flights. It was a hugely botched deal all around. Okay, due this week, we've just got a discussion question. I want to get your thoughts on privatization, government contracting. So thank you very much for listening. I hope you guys have a great week, and I will see you on the discussion boards.